All right, we're going to record this next little bit, like I said, for posterity's sake, because we recently had some changes with the legislative session that go into effect May 7th. So we have a few weeks for this. How many of you guys have read the division newsletter? Comes out every quarter. Richard, by the way, thank you for joining us. I was just thinking about you this past week. I hadn't seen you in a while. It's good to see you. I saw you unmuted, but I still couldn't hear you.
I said it was a very good ski season.
Good. That's good. When you can disappear for a few months and live on the mountain. Anyways, if you saw this last legislative, or you saw the last division's newsletter, there's a couple big things that stood out, right? How many of you scroll right to the bottom to see all of the people that got fines? Yeah. Um, did you notice anything different about that list? It's way shorter. Normally that goes on for pages of little ticky-tack things. Well, that's kind of a direct result of this legislation that we're going to talk about. You may have also noticed that the biggest fines you probably ever saw were on there. $100,000 fine this last newsletter. So what we want to do today is have a discussion about, hey, how do we protect ourselves? What kind of things are coming up, just so that, we're sharpening the saw. We're avoiding potential run-ins, and we're educated so that when we talk to clients, they know what we're doing. One of the other things, as mentioned in the training calendar, is in addition with this legislative session, they talked about mobile homes a little bit more. And so we're going to do a little bit of a deep dive into that. So without further ado, let's get started. I'm going to share my screen with you, and we are going to look at the revisions to state law that will go into effect May 7th. Now we're just going to scroll down. They've done a really nice thing for us is they have put in red print, underlined the changes. So we're just going to check out the changes that are in there, because I'm sure you all go in and read state law just for fun like I do every week, right? So anyways, a couple of things that I really like that they made with this last session is they have opened the door to not identify the person publicly. So they've given us a new term. These are all just in the definitions section. It's the very first section of the ruling where they just define everything, right? So they've added a few new definitions. We've got admonitions now, which is a public discipline that declares the conduct of somebody as improper, but it doesn't identify the person. So that's one of the reasons we don't have that 3-page list of people that have made violations, because they're more of an admonition than a violation that requires their name to be published. Okay, so that's a new definition that we've got in there. That's why we'll see the newsletter that's shorter. Doesn't mean that there's less problems going on. It's just they're qualifying for a minor offense, I guess, and they don't have to be identified publicly. Another thing that's been clarified with this is the
Eric,
of advertisement. Yes, sir.
I'm just curious. Have you ever been down to the commission? Have you ever gone in and listened to them? I'm just curious how what one of those meetings is like.
So one of our brokers is actually a commissioner, Randy Smith. He's one of the current commissioners, and I haven't sat in on one of their meetings, but I've been through this proceeding here with some of the commissioners on there, and I've talked with Randy quite a bit, and he doesn't share details because a lot of the stuff is confidential, but they do have very good discussion. They're very frank with the Division of Real Estate, saying, hey, these are the real problems. This is where the focus needs to be. And I think that's where a lot of this direction has come from.
I think that's probably good. Thank you.
Yeah, we're cleaning up a lot of things. So one of the things that's been clarified is advertisement. So it says that an advertisement is meant to promote real estate or, specific sales, offer specific types of brokerage services, or solicit the public to contact that licensee for more information. What it does not include is if I'm doing a TikTok post and I'm dancing and I'm showing my moves or whatever it is, and I'm a real estate agent in my post, I talk about it, but I'm not specifically promoting real estate. I'm not specifically offering brokerage services or specifically soliciting that they contact me for more information. That's now not an advertisement. So again, the division was getting swamped with a lot of these little ticky-tack things. And again, since it's media, it's really easy to send that over to them as a complaint where we it doesn't sound good, but rat out our competition. And honestly, if your competition is doing things that are bad, that's harming the public, rat them out by all means. Okay, we are not operating on gang level where we don't rat out people. If there's people that are actively harming the public, we need to get that taken care of. Okay, that only helps our industry. Hiding that fact is a bad thing. It could be a criminal thing. Like, for example, if I'm the broker and I find out about it and I hide it, that's actually criminal. I can get in extra trouble for doing that. So no, but at the same time, years ago, they had this advertising rule that the name of the brokerage had to be 50% the size of the largest print. And agents were out there actually measuring their competitions, like, oh, they're off by 2 millimeters. It's undeniable. They've broken the law. Stupid stuff like that, right? We don't need to do that. We're looking for people that are actively harming. Anyways, this kind of clarification to the rules helps get rid of some of those ticky-tack offenses. Okay. So clarification and some definitions, and then brokerage also has been defined. And this is good because I had this discussion with one of our agents just last week. He's like, finally, thank goodness I don't have to say equity real estate premier elite on every ad that I run. It's just too long. I can just say equity real estate. And so now they have clarified that brokerage, because brokerage name has to be in all of your advertising, right? And they have now defined brokerage name as the name of the brokerage as shown on division records, which is equity real estate. It is not equity. So when you're doing your marketing, if you just say equity, that is not sufficient. I've had division investigators contact me about my agent's marketing and say, hey, they need to pull all of that. It just says equity. Even if it's the equity logo, but it doesn't say real estate underneath it, that's not sufficient. It has to say equity real estate. That's the name of the brokerage as shown on division records. You could use, if you want to, the name of a branch office. So equity real estate premier elite or equity real estate advisors, if you want to, okay? Or a DBA of the brokerage. And for us, that's not a factor here. So equity real estate, you can use that. If you want to use your branch name, you can use that because that's also registered with the division. And anyway, so that clarifies for some of you because you've tired of writing equity real estate premier elite on everything that you do. You can just do equity real estate. All right, let's jump down. There's the DBA. We don't need to discuss that. And again, this session is talking about factory built housing, manufactured homes, or mobile homes. Okay, so manufactured or mobile is now brought under the scope of the division of real estate. I'm going to expand my screen so I can see you guys a little bit more. This is live. If you have questions or comments, you can just click the little button to raise your hand and then unmute yourself and we can have a discussion on this. And this is what we're going to do with our deep dive. But for years, when I was president of the Brigham Tremont Board of Realtors, I got to go to the state meetings, and every single meeting that we had, somebody raised their hand and said to the director, which I believe was John Stewart, if I'm getting that wrong. Now I'm thinking that might be a late night talk show host. Johnny was what we called him. Anyways, they would always ask him there and say, hey, what are the plans for mobile homes? And the director at the time, and this is going back, I think, 3 years now, but the director would say, look, mobile homes aren't technically under our purview. We know you guys are doing them, but the law doesn't specifically address it. And so here's what we can tell you is, number one, you shouldn't be putting earnest money from a mobile home into your trust account. Mobile homes, by definition, are not real estate, and it is a real estate trust account, and we could consider that commingling of funds. The other thing I can tell you is that you should not use the real estate purchase contract because, again, mobile homes by definition are not real estate. They are personal property, and the real estate purchase contract should not be used for those. Beyond that, they didn't give us any further direction. So we went in, we as an equity real estate, we got our attorneys because the state law says with forms, we need to use state approved forms, but in the absence of those, our own attorneys can create them. So we created forms to make it possible to do mobile homes correctly under that new direction from the director at the time. All right. And that's what we'll go into our deep dive with. But now, as of, well, it'll be in effect May 7th, factory built housing, which is manufactured homes or mobile homes, are now under the purview of the Division of Real Estate. So I anticipate we do have a broker on the forms committee. I talked to him last week. He said there isn't anything in the works yet, but I do anticipate that we will probably see a sales contract being developed for mobile homes, but we already have one. If a new one comes out, then we'll start using that one. But for now, and again, for the last 3 years, our agents have been able to do mobile homes under the proper direction of what the Division of Real Estate or the director of the division had mentioned. So all of this section here is really just talking about mobile homes, manufactured homes. Again, by definition, they're now under this umbrella. And so we want to jump down here. Again, they're giving us a definition of a reprimand. It's a public discipline that declares the conduct of a person as improperty and includes the name of the person. So we had one definition that doesn't include the name, and then we've got a reprimand that does include the name of that person. They're defining a transaction down here. And then let's jump down to this one right here. Okay, this is an interesting change, and I had actually a lot of feedback into this section 5 right here. The idea is we have this legal concept of agency by implication, right? And the idea is that if I'm representing a seller and an unrepresented buyer calls me up and I help that buyer to a certain extent, then I have created agency by implication. That buyer doesn't know any better. They think that maybe I'm their agent. And then later on, they come back and they sue me saying, well, I thought he was my agent, right? And I wasn't ever their agent. I was the agent for the seller. But since they didn't know any better, they make this claim of ignorance. And all of a sudden I have liability for that. So this law is addressing that scenario. So it's the following conduct by a principal broker who represents a seller does not create an agency relationship. So it's specifically saying this is not agency by implication if we do these 3 things. Contact the buyer directly. And again, this is a buyer that's unrepresented. Okay. If it's a represented buyer, then we still need to be going through their representation. But if we contact them directly to discuss items related to a real estate transaction between a seller and a buyer, we're representing the seller, that does not constitute agency by implication. Providing the buyer with blank forms. Now, this is interesting because even with some of the previous definition, it wasn't defined as blank forms. It was state approved forms, and the state approved forms, there aren't hardly any of them. It's just basically the real estate purchase contract for all applicable purposes. It's the real estate purchase contract and a blank addendum. But now it's blank forms, period. Most of these forms are copyrighted by the UAR, Utah Association of Realtors, that has created these forms to solve problems for their membership. But this says that it doesn't create agency by implication by providing this buyer with forms. And if negotiating the terms of the transaction between the seller and buyer. So we're engaging in negotiations back and forth. That doesn't create agency by implication. So the question is, how far can this go? And there's brokers that I've spoken to, that I serve with on the board of directors, that say, you know what, when I'm representing a seller, it's my fiduciary duty to do everything for that buyer so that that transaction goes through smoothly. I disagree with that. I think we take the law at face value. We can provide forms, but then that buyer fills out the forms incorrectly, right? So then we get into coaching them through the forms. Well, here's what you need to do here, and here's what you need to do here, and fill it out this way. In fact, why don't I just fill it out for you and I'll send it to you with .loop for electronic signatures? Have we now crossed over the line and created agency by implication? I would think so, yes. So when this says providing with blank forms, I want you to hold your ground. When they say, hey, can you help me do this? Absolutely, I can. But state law only allows me to provide you the forms. Once I help you in filling out the forms, I have liability for the rest of the transaction as your agent. As such, my company's going to charge me X amount of fees. And so I'm going to do this for you for $1,000, or I'll do it for you for 1%. One thing that you don't want to do is, you don't want to fill out these forms incorrectly. It could put you at a disadvantage. And obviously, this is a conversation that you would have with your seller. And if you guys have stayed up to date on the listing agreement, they have added a section in there. What is it? 2.2 that talks about the contingency of, if there is an unrepresented buyer that comes along, am I going to charge a little bit extra? Right? Because they aren't easy. It's not. Sorry. I'm going to go spank my dog if that continues. Sorry about that. It is not easy to deal with unrepresented buyers, right? They have trouble going through the inspection. Everything scares them. I haven't had an unrepresented buyer get across the finish line for a couple of years. So if we're going to get involved and help them, it's going to cost a little bit more. And the listing agreement that we have brings up that discussion. It should bring up that discussion. And so since we're already having that discussion with the sellers, hey, if this scenario comes around, as mentioned here in section 2.2, here's how this is going to be. Maybe we also have that same discussion with buyers. We say, this is what state law allows me to do. If you need more help than that, I'm happy to assist you, but this is what it's going to cost you. I will not do it for free. I will not put my own license at jeopardy. No single transaction is worth your career. All right. So even though you might be thinking like that, this other broker that I work with on the board of realtors, you might be thinking, hey, anything I do for my sellers is in my seller's fiduciary duty. That's in their best interest. That is not true. All right. There are rules that still apply. And yes, you help your seller out up to the limit of the rules. But the rules stop when it says do everything for the buyer, as in the best interest for your seller getting through that transaction. The rules do not go that far. So I want to make sure we're all very clear on that. And again, you guys are free to reference state law and say, state law allows me to do this much. If you need help filling out these forms, then I am happy to do that. I'm going to charge you $1,000 for it. And just so you guys know, Equity is going to have an entire file for that buyer, because at that point, once you're helping them fill out the forms, you have created agency, and then we have the minimum record keeping requirements, which is this section down here, of you. So we have this requirement of you. And that is, and by the way, I really like this next section. Any questions on this one before I move on? This is one of the most directly applicable ones to real estate agents, section 5.
I appreciate you clarifying that. Thank you.
Thanks, Richard. Okay, so record requirements. Let's talk about this. This one I love, that we have, and you guys all know this. This was state law when you took your test, right? So we've got to keep or possess any applicable record of the transaction. Let's see, for 3 years following the day the transaction either closes or fails. In a lease transaction, the commencement of the lease, the day an offer is rejected, or the end of the term of a property management agreement. So we have to keep records for 3 years. What did the old law used to be? 10 years. Well, excuse me. Let me address this. We had to keep records for 3 years, but they could ask us for records going back 10 years. So if I'm managing the brokerage, and again, this doesn't matter as much to you guys as it does to me as a broker, but the state law said after 3 years, I didn't need to keep a copy of those records. So let's say that I had disposed of them. Well, the division could come and ask me for stuff going back as far as 10 years. And if I said, well, I don't have them because you said after 3 years I didn't need to keep them, then they said, well, then how are you going to defend yourself against this claim? And it didn't help that the division was 4 or 5 years behind in investigations. If any of you guys have filed a complaint with somebody and you're like, how is this person still out there doing the same thing for years after you filed the complaint, after you've alerted the Division of Real Estate to their bad behavior, their bad practices, they're doing it for years, like nobody's even looked at the complaint? Well, it's because nobody had looked at the complaint. They're like 4 or 5 years behind. Well, all of this is being addressed with this change here. So let's keep scrolling down just a little bit. Again, this talks about that advertising thing, so it's a little bit off of this topic. We're going to come back to this topic, but let's jump and look at this advertisement. So with an advertisement, if it's online, if the advertisement is placed online or in a digital format, a link to a website or media platform that identifies the brokerage name within one click. So you have to have, if it's online, then there needs to be a link that identifies the brokerage name within one click. That hasn't really changed. The only thing that changed maybe is that before it used to say if it's a small enough format, like for example, a Twitter or something where you're limited in character spaces, then you had to be one click away from the name. If you weren't limited in character spaces, then the name had to be there. I still think you should probably just put the name there if you're doing social media marketing. But if for some reason you can't, again, it's got to be identifiable within one click. Do that. All right, let's go back down here and look at this. Okay, so the division may not require the production of evidence, book, paper, contract, record, other document, or information required to be kept by a brokerage after the expiration of the time in which the brokerage is required to maintain and safeguard the record, as defined in section 61 2F 309. So 3 years, right? And this is a huge change for us because they used to be able to, let's see here. Used to go back 10 years where, yeah, it might be further down. Anyways, so now instead of them being able to go back and ask for stuff up to 10 years
It's right
old.
there in the blue.
They're in the blue. Oh yeah, right there. Okay, that's what it used to be. Isn't that wild? That we're only required to maintain records for 3 years, but they can ask us for those records for 10 years. That's just a messed up law. So we fixed that with this legislative session. That's a good thing. So they can go back and they can ask for stuff for 3 years. Now, what that means is since they're so far behind in things, it means that, hey, we need to focus on the real bad guys here, not the person that did the TikTok video dancing around that forgot to put the name of the brokerage on there. We shouldn't be focusing all of our time and attention on them. We should be focusing on the people that are absconding with hundreds of thousands of dollars by mismanaging a trust account or actively defrauding people, or whatever schemes are generated. No offense to you folks from Utah County, but it seems like a lot of schemes come out of Utah County. Anyways, that's a good change. It doesn't affect you guys so much. We still have to keep all of our records, but it helps us as far as brokers go in managing things. There are a couple ways that they can extend that just a little bit out. Like, for example, if there's an active thing in court and that extends beyond the 3 years, then they can say, hey, well, this was an active investigation or this was an active proceeding in court. So we want to be able to still go back and get those. They can still, if they want to, they can post admonitions, reprimands, suspensions, all those new definitions that they just learned. They can post those in the division newsletter if they want to. Nothing restricts them from doing that, but they don't have to either. So that's a nice change. And then I do like this section right here because it gives, if you've ever played with the Division of Real Estate, they haven't always played fair. They sometimes look at somebody and say, well, you make a lot of money, you're highly successful, or you're very visible, so we're going to charge you more. We're going to make an example out of you, right? And I've literally heard those words out of their mouths. We're going to make an example out of you because of your size. So this says now that in determining the appropriate action, they're going to consider the following factors: the seriousness, nature, circumstances, extent, and persistence of the conduct, the harm to other people. That's a big one. They should have always been considering that, right? The cooperation of the person in any inquiry conducted by the division concerning the violation. So when you get a letter from the Division of Real Estate that says, hey, we need a copy of this file, we need it within 10 days. If you don't get it to them within 10 days, that's this whole separate violation. But the quicker you cooperate with them and the more fully you cooperate with them, they actually consider that in whatever penalties they decide to give you. The efforts that you make in trying to prevent the future occurrences. You know what? I'm really sorry about this. I didn't understand it fully. I'll make sure that I don't ever do this again. The efforts by the person to mitigate the harm caused by the violation. You know what? I can see that this harmed this person. I'm going to make it right. The history of previous violation. If you're continually violating things, things get worse for you. The need to deter the person or other persons from committing the violation in the future, whether the violation happened against a vulnerable adult, which is usually somebody 65 years old, older, or somebody vulnerable, like there's some kind of a handicap, or sometimes there's a disability there. And that definitely compounds the seriousness of it. Or if there's any direct or indirect compensation or economic person the person committing the violation received, or other matters as justice may require. So anyways, they're trying to say, look, we're going to try to consider all of these factors in how much punishment we issue to you. If you didn't harm anybody, if it was an honest mistake and you immediately went to fix it, all of those things are now considered in how we're handling things. And so again, when we look at the division newsletter and we see that we go from 3 pages of people mentioned for lots of little things, and we're down to now 3 people listed for all potentially very serious issues, that's kind of a direct implementation. Even though this doesn't go into effect until May 7th, we're already seeing it kind of enact. All right. These discussions have been going on for a while between the commission, between the Division of Real Estate. It is not a surprise to the Division of Real Estate that these things are being enacted into law. They've seen this coming down. They've already adjusted a lot of their behavior and actions in accordance with this. And so even though it doesn't go into effect, we're already seeing the effects of it. And those are all good. All right. Any questions on this stuff before I jump into our mobile home thing? Okay, let's jump into our mobile home thing. I'm going to take you now to dotloop. This is my test client from Somewhere Street in USA. I use this whenever I pull up forms that we have available for you. And let me adjust some things on my screen so that I can access everything. All right. So some of you have called, in fact, somebody called me just yesterday and said, hey, I've got a chance to do mobile homes. What can you tell me about it? And I said, if you can wait till tomorrow, we're going to do a whole thing on this. So again, as I already mentioned it earlier, state law didn't really address it. It will now. There will probably be some forms coming down, but our agents have been able to do this effectively and legally for the last 3 years based under the direction of Director Stewart back then. So if we go to add documents and go to template, we can just come up here in the search bar and learn how to type first and put in mobile. And there's a master mobile homes forms. There's a little folder in there with that, right? So we've got an indemnification agreement. I'm going to check them all so that you guys can see what these forms are. We're just going to add them all in. And then we'll open them up and see what we have for you guys. So one of the first things, looks like the mobile home. Oh, we've got a buyer packet checklist and a listing packet checklist and an under contract packet checklist. So let's look at these forms real quick. The first thing that you need to understand about mobile homes is if you choose to do them, and you may choose not to. You may have somebody that comes to you saying, hey, we want to buy this. And you might say, you know what, I don't do those. Let me refer you to somebody that does. And if you need somebody that does them actively all the time, I have agents that do that. And I can give you a name and you can get a referral fee. Personally, I don't love doing mobile homes. But if you want to, there's something that you need to understand, and that is that Arizona Emissions Insurance does not protect you in these. Arizona Emissions Insurance is specifically for real estate. It is not for mobile homes. And so you need to sign an indemnification agreement that you understand I don't have protection of E&O insurance if I choose to take this on. Okay. So it comes down here. It defines everything right here. You sign it and I sign it, saying that we both understand that that there are some things there, that some extra responsibilities, I guess, on you by deciding to take on a mobile home agreement. Okay. So anyways, you're indemnifying the brokerage and all of that stuff. You know, any liens or fees that come in lawsuits, you're basically accepting responsibility for those types of things. So with this one out of the way, let's say that you say, okay, I'm still good. I want to proceed with it. Now we've got your checklist. This is everything that you need. Now, a couple of things again that are going to be different here is, in fact, let's jump down to the actual, before we do the checklist, let's look at the sales contract. So we've got right here some information for you, and I'm just going to read through this so that you have this. Equity Real Estate adheres to the idea that unless a mobile or manufactured home has been permanently affixed to real property, it does not constitute real property. In many states, unless a mobile or manufactured home has been permanently affixed to real property, your real estate license does not authorize you to represent someone in a mobile home or manufactured home transaction. On the other hand, the law in most states does not prohibit you either from assisting or representing someone in this type of transaction. Upon direction from the Division of Real Estate and our equity attorney and all its branches throughout the country, we will allow mobile or manufacturing home commissions to be processed through our payroll department, but we won't accept or hold deposits for these transactions because, again, the director said this could be considered commingling of funds. You're handling stuff for personal property in a real estate trust account. We will also not hold, process, or facilitate the distribution of any funds related to these transactions except actual commissions paid to our agents or fees paid by our agents. All right, so we're not holding money for people. We can pay the commissions, but that's it. So here's the sales contract. You'll notice right away there's different things.
Before you leave that,
yes, sir.
So what would you suggest that we do with it? And I don't know that I want to do mobile homes either. But before you leave that, so if we collect money, earnest money is what I'm calling it, but whatever you want to call it, what should we be doing with that?
Well, let's go down to the contract. That is the key question, right? So first of all, we notice right away we don't have earnest money listed up top, right? That's where there's a difference from the contract. We've got the client's name. There's a few things here that are very particular with mobile homes. We need license numbers, serial numbers of the mobile home, a VIN, year, manufactured, size, whatever. Okay. We need different information than a real estate contract allows us to fill out. And this is important information. So if we're using a real estate contract, not only does it have a whole bunch of information that we don't need, that doesn't pertain, it's missing a lot of fields that we do need. Okay. So this is one of the first things that we need is we need to get all of this information. And we've got the buyers and the sellers information right here. We've got the purchase price, and it's a deposit at acceptance. It's not earnest money, it's a deposit. And where are we going to hold the deposit? And again, we've got it right here. No deposit money may be held at Equity Real Estate. So when you're buying a car, Curtis, Richard, sorry, don't buy your last name. When you go to buy a car from somebody, not from a dealer, you go to buy a car from somebody and they say, okay, yeah, you can take it, do a test drive, whatever. Where do you hold that deposit? Give us a deposit or something.
If it's only for while I'm doing a test drive, they're going to hold the check.
Yeah, they might hold a check, right? So again, it's kind of the same thing. We're dealing with a great big vehicle. So who holds the check? It's up to these guys to decide it. We're just going to tell you there's one place you're not going to hold it, and it's not going to be in our trust account. Okay. Real estate agents, it's not going to be in your back pocket. Okay, I'll just hold it right here. Take good care of it. No. Okay. We're not the responsible party for that. This is between buyer and seller. They can decide where it goes. All right. So there's the deposit of the contract, the remaining purchase price at closing. There's the total. Now we've got seller disclosures. The seller shall have until the seller disclosure deadline to disclose to the buyer any material defect in the mobile home known to the seller. Seller shall inform the buyer of any defect that arises between the time the disclosures are delivered to the buyer and the closing date. Seller shall also deliver to buyer the contact information of the HOA park community where the mobile home is located. Again, this is a very different section than the seller disclosure section listed in the real estate purchase contract. But it still allows for seller disclosures to be provided. And then the buyer gets a chance for their due diligence. They can perform or have performed on their behalf any inspections that they determine necessary to evaluate the mobile home, the rental agreement for any land where the mobile home is currently located, any rules and regulations of the HOA park community in which the leased ground is located, or any other tests or inspections deemed necessary by the buyer. The buyer shall have until their due diligence deadline to perform all these inspections. In the event that the buyer in their sole discretion is not satisfied with any findings, they can cancel this agreement by 5 p.m. on that deadline and receive a full return of their deposit. Again, great language, a little bit of a variation than what you see in the purchase contract, but kind of the same vein of thought there. You have a chance for home warranties. There are companies that do home warranties for mobile homes, so you can just decide if that applies to you. Whether or not there is financing required matters here. Their chance to cancel the contract before the finance and appraisal deadline, right? So again, you see a lot of similarities that the real estate purchase contract has. We've just tailored them to the mobile home contract. And then rather than talking about earnest money being released, we have changed that to the deposit. All right. So for example, right here, if buyer's sole discretion is not satisfied with the terms and conditions of the loan, they may, after the due diligence deadline, if applicable, cancel the sales contract by providing, because it's not a real estate purchase contract, it's not a REPSI, there's no real estate involved, it's just a sales contract, by providing written notice to the seller no later than the financing and appraisal deadline, whereupon, however blank, all of their deposit shall be released to the seller, or none of it, whatever. They can, this is basically a term of how aggressive we're negotiating. So if we wanted to be really aggressive, we could say, hey, we're not going to get any of our deposit back if we cancel on financing. We're very certain of our financing right now. All right, buyer's right to cancel after the finance and appraisal deadline. So if after the finance and appraisal deadline has passed, the buyer fails to obtain the loan, then the buyer shall not be obligated to purchase the property, and they can cancel the sales contract by providing written notice to the other party. And if that sales contract is canceled as provided in this section, the buyer agrees that all of their deposit is released to the seller. So again, we're treating the deposit just like earnest money. It's addressed all the same way as we're familiar with in a real estate purchase contract, but we've got the correct language in here so that there is no confusion about that it was a deposit, not earnest money, etc. Okay, so all those things are built into this. We've got a section, same thing with appraisal, if they wanted to do that.
Eric?
Yes, sir.
Sorry. I was just thinking, you don't want the deposit being in the back pocket of the real estate agent, right? So, just curious, like if it's you're helping a friend out type of thing. I mean, can anybody but me, like, can my wife hold on to the deposit? Is that considered okay, or is that too gray area? Not to worry about it and don't even go there, or what?
I wouldn't be involved in it at all.
Yeah, that's what I'm thinking too.
No reason to have that liability. This is between buyer and seller. If it were me, I'd have the seller hold it, but just make sure that they understand that, hey, there's these other. So yeah, I would have the seller hold it personally. It's up to you guys, or if they have a third party that they trust or something like that, that's completely up to them. But they need to understand the rest of this contract that says, hey, you don't get to go out and cash that check and spend that money, right? Because we have a chance to cancel based on inspection. We have a chance to cancel based on our finance and appraisal deadlines. So as long as the seller understands that clearly, they understand the contract, then they should be fine holding it that way. Okay. So
Thank you.
All right, let's look at closing, because closing is different. The transfer of funds, which is the purchase price in exchange for the mobile home title and bill of sale, shall be coordinated between buyer and seller. If wiring commission dollars, please include the commission disbursement and wire instructions form. So if we're bringing our commission into it, then we can have them wire it. They can give us a check. We don't like checks as much because if the check bounces, that's ugly. But this closing, it's usually not done at a title company, because title companies don't like to be involved in this. They don't want to hold the earnest money. I have heard of some title companies that will for a mobile home. Most of them will not, because again, it's not real estate. And so we're coordinating this. Here, we'll give you the money. You give us the title and the bill of sale. Again, it's just like a big car sale. All right. And then we've got a date that it needs to happen by. And we've got the penalties if there's failure to perform, which is basically the deposit. And we're, again, handling these penalties very much like earnest money is handled with a breach of contract in the real estate purchase contract. All right. The other thing that we've got here is that the seller warrants that is the legal and true owner of the mobile home has the right to sell the mobile home to the buyer. Seller further warrants that the mobile home is sold free of any encumbrance, lien, mortgage, lease, security, interest, or claim. A seller shall defend buyer against any claims against buyer's title. Again, don't really get title insurance for this mobile home. And so we've got this statement in here saying that it's free of any encumbrances or liens. Then we have a chance to put in our deadlines, and we've got the buyer's brokerage, seller's brokerage, and there you go. Down here, registration and ownership transfer. Upon receipt of the full purchase price by the seller agrees to promptly take all legal actions necessary to execute all paperwork necessary to transfer ownership and registration of the mobile home to the buyer through the state DMV. Buyer shall be responsible for any and all sales tax incurred by the sale of the mobile home. So again, just like a car sale would happen, right? Mobile home shall be broom clean and free of all personal property, and seller shall deliver physical possession of the mobile home to the buyer upon receipt of the purchase price. Buyer shall be responsible to transfer title and payment of all sales taxes incurred. Buyer shall also transfer all utilities, if any, into buyer's name to be effective as of the closing date. So again, we built this contract, and I think we've thought of everything, but we ran it by a few of our agents that have done a lot of mobile home sales. They helped us say, hey, you know what? In mobile homes, there's these other considerations we need to have, or these things aren't in place. So I think that you'll find most of the things in here that you need, so if an agent calls me and says, what do I do with a mobile home sale? If you read our mobile home sales contract, it pretty much guides you through the process. What you need to understand is that, yes, it's true. We're not holding this earnest money. We're not holding this deposit. That is handled differently. And all of the things that are handled differently are in the language here. So once you get in and read through the language, it's a pretty good guide for a buyer and seller, and even for their agents, on how to properly handle it. And then we've got a section in here. If you need to add a few bits of additional information, then you can, and everybody signs it. All right. Now we've got our under contract packet checklist. And you'll notice that there's a lot of the same things that are still required. You've got to have the loop. If there's a referral or anything like that, we've got to have those forms right up front. But the commission disbursement wire instruction form, the mobile home under contract packet checklist, if it was on the MLS, a copy of that. And again, we've got real estate purchase contract. We should probably fix that for this one. It's not the real estate purchase contract. It's the sales contract right here. And then the seller's disclosures, a bill of sale, copy of title, accounting of proceeds, and copies of distribution checks or wires. So we get copies of all of that stuff. And so your checklist kind of guides you through all the forms that you need to have. Same thing up here with the listing packet. If you've put it in, you're still going to have an exclusive right to sell listing agreement. Same one as ever. And then all your MLS forms, seller's disclosures. If it's the wire fraud disclosure form, the mobile home indemnification, all of that stuff would be in there. So I'm thinking that if you follow through these checklists, it's a pretty good guide. I do notice that we've got a few things where we're mobile home buyer packet checklist, where we've got earnest money receipt. We should probably address some of those. I'm going to make a note of those for corporate as we're talking. And we'll get those things, the language on them changed. But any questions that you guys have on mobile homes? Okay, so again, the summary is mobile homes in the past, state law has said, hey, we don't really say you can't do it, but there's nothing that says you can do it. Here's the direction that we can give you. Don't use a real estate purchase contract. Don't use your real estate trust account. So we've created these forms that allow us to do it. Now state law is changing, saying, okay, you can do it. It is under our purview. And as such, we anticipate the forms will be coming. We don't have those forms yet. So this is what we have. Our attorney is actually on the forms committee. We have another one of our brokers on the forms committee. A lot of the changes to forms that come back are things that we have created for ourselves years prior to. And it just takes a little bit longer to get through that process. But I think you'll notice when the new forms come out, you'll see a lot of similarities between what we've created and what they eventually create, because we've kind of spearheaded that. So it's kind of fun to be at the forefront of these changes, making good changes, making positive impacts on the real estate industry as a whole. But if you want to get into mobile home sales, you certainly can. Just make sure that they are done correctly. Make sure that you have read through that contract with your clients. that they make sure that any deposit that they've received could potentially be going back, and that they've got to wait for that due diligence time period or the finance and appraisal time period to expire before that deposit is theirs, because somebody's got to be holding that. We just want to make sure that check doesn't get cashed and spent in this process. So those are the big considerations there with mobile homes. Other than that, you've got your same checklist there. So any questions for me?
Eric, I sincerely apologize if you've covered this, but where would we go to check for like liens or anything like that on a mobile home, since title companies don't usually cover them?
All we've got is their signature there saying they certify that there aren't any liens on it. So yeah, it's not really something that I know of, a place where we can go to check. Does anybody else know of a place to check for liens on a mobile home? I don't know of any. So they're signing saying there aren't any.
Maybe the DMV?
Maybe, but are changes to or liens on a mobile home reported to the DMV? I don't know that they are.
I don't know. It's a vehicle, so.
Yeah, it's a vehicle. I don't, like, if I hired somebody to detail my vehicle and I didn't pay them, I don't think they get to go to the DMV and somehow on my vehicle title.
Yeah.
So anyways, yeah, Kelly, that's a good question. I don't think there's a good answer for it. All we're doing is getting their signature on that saying, all we're doing is getting their signature on it saying, yeah, we're certifying that there aren't any. And then that gives us something that if something comes up later on, we have a piece of paper that we can take to court where they said, hey, they certified there wasn't anything. We've got the piece of paper here where they've signed it saying there wasn't anything, and yet there was. And that makes it a pretty easy case for a judge.
I have a quick question. So at the beginning you mentioned this was all the process if the property is particularly not embedded on the land, it's not a permanent fixed. Once it is, do we still use the same set of contracts, or then it goes to the REPC?
Then it's the real estate purchase contract. That's a great question. So the question was, if you didn't hear it, what if it is a mobile home or a manufactured home that is on land that they own, right? And they've done a permanent, and Alan, maybe you can talk to this a little bit as far as financing goes, but they've usually not a mobile home. They're not usually attached permanently, but a lot of times manufactured homes are brought in on a truck, drop down, permanently attached to a foundation. Alan, how does lending look at those things?
It's kind of sticky. So if you're talking about lending on manufactured home, and in the lending world, we're going to call mobile homes manufactured homes the same thing. If it came in on a trailer, we're going to call it a manufactured home, whether it's a double wide or single wide, whatever it may be. If the property is not attached, and if it's located in an area where there's a mobile home community, there's an HOA fee that you're paying, or a lot lease, something like that, then that financing is not going to be through a mortgage entity. It's going to be through some kind of a personal finance entity. And there's a couple of companies in the country that do those. They are fairly difficult and limited to get, in my experience. You got to go straight to those companies. If there's land involved, then you get a little bit sticky in the situation where if the property is not attached, in other words, they're buying the property, buying the land, and there's a physical structure on top of it. There's no good way to finance that unless you first do an official attachment of that land and the mobile home. So typically what you end up having to do is go through the process of getting an engineering report and then get a certificate I think it's called a certificate of a fixture, where you go in and it's pretty easy. We've done them in Duchesne, Weber, Box Elder, Cache County. In most of those counties, it's the sheriff, oddly, that goes out and signs the form saying that they're attached. I don't know why the sheriff is the guy, but that's the guy. In Box Elder County, the sheriff shows up and goes, "Yep, your mobile home with your manufactured home is attached to the ground."
It's a VIN inspection, essentially. It's
Yeah,
the
that's
VIN
it.
number, and it's an affidavit of a
Yep.
fixture. Is the document.
Is it attached? That's it. And so, thank you, Monica. And so you just go through the process of getting that done, and then you can do financing on it as just any other type of real estate. But if it's a manufactured home sitting on land and they're not affixed, that becomes really challenging to finance, because lenders don't want to do a lot loan or a land loan if there's a structure on it, and they don't want to do a structure loan if it's not affixed. So you kind of have to get it affixed to get financing on it, unless it's seller financing. If it's in a park, you're looking at seller financing or one of these, non-real estate based, vehicle financing essentially. And the rates on those are going to range between 9.5% to 11%. And they're going to want to have 10 or 20% down to get the financing on the manufactured home just sitting in a park. Did that help?
Yes, thank you. Did that answer your question? Okay.
Yes, thank you.
All right. Any other questions? So here's the big takeaway today. RPAC is valuable. If you're not familiar with that term, it's the Realtor Political Action Committee. Every one of you, there's a suggested minimum donation of like $15 a person. It is not a lot. But in order for these bills to be passed, first of all, there were just shy of 1,000 bills in Utah brought up in this last legislative session. The session is 45 calendar days, which gives them about 33 actual days to review just under 1,000 bills. Just under 600 of those bills were passed. Who do you think is scanning those bills to look out for things that either scanning or helping prepare those things to protect home ownership, to make our industry make more sense, like that whole keep records for 3 years, but we can ask for records for 10 years debacle? That was ridiculous. And it's been ridiculous for nearly 20 years. Who is it that does that? That doesn't magically happen. We don't magically have congressmen that are so well versed in real estate or the law that all of a sudden they come up with these brilliant ideas. These are things that are promoted by RPAC, the Realtor Political Action Committee. And the people at RPAC, here in the Northern Wasatch Association of Realtors, our CEO is very actively engaged with that. The UAR CEO is very actively engaged with that. And because of that active engagement, and because they're doing good things, we're not just looking out for our own industry, like what makes sense to keep realtors in business and get us more money. That isn't what it's about. It's about this protects home ownership rights, right? And yes, some of these rules in here did clear up a lot of things for the real estate industry, but the primary goal is to protect home ownership rights across the board. And by doing so, that helps our industry, right? So anyways, none of this stuff is free. There's people that are very smart that are investing a lot of time into it. And that all happens through your RPAC donations. And I'm not here to, I think you get enough of this at the board meetings, if you go to the board meetings. But I will tell you that good things were done in this last legislative session. And people wonder sometimes, what do my board dues get me? Why do I have to pay this? It comes up every year. This is one of the big things that it does. But they do ask for voluntary contributions to the Board of Realtors for RPAC. And I've been a major donor of them for years. A couple of years ago, I was inducted in the Hall of Fame for RPAC. I've got a little plaque that overlooks the Capitol building in Washington, D.C. But I'm convinced that if it weren't for those types of donations, that our industry would be completely unrecognizable. None of us may even have jobs, right? But these changes that have been put into place here have been good changes for our business. And I think we owe some thanks to all of those people that worked really hard and to the legislators that helped draft this. So I will end with that.